Good morning, ladies and gentlemen. A very warm welcome to each one of you to the second one-day international conference on construction law and arbitration at Mumbai, jointly organized by SCL India and its Mumbai chapter. We are truly honored to have an exceptional gathering of legal luminaries, industry experts, and distinguished guests among us today. And to formally welcome and introduce our distinguished dignitaries to the audience, may I now invite Mr. Panchmatia, Partner Keating & Co. and Secretary SCL Mumbai to kindly take the stage and guide us through the introductions.
Thank you, Akshay. Good morning, all of you. Thank you for coming here on a Saturday morning for this session. We've seen that construction work in India and construction industry in India is growing at rapid pace. And today, we are here to have our second conference in Mumbai for the Western region, Construction Law 2.0, Building a Better Tomorrow. We have with us today a very eminent gathering of members who will be sitting on our inaugural panel. We also have some very interesting sessions through the day, and we'll be very happy and we are very happy and honored to see the entire house full today. And for our second conference, actually, we are very, very happy that we are seeing this entire hall which is completely packed. With no further ado, I would like to now introduce our members for the inaugural session. We have with us today Honorable Justice Rajesh Bindal, Judge, Supreme Court of India. It is with great honor and privilege that we welcome Justice Rajesh Bindal, a distinguished jurist and currently Judge of the Supreme Court of India, who assumed office on 13 February 2023. Born on 16 April 1961 in Ambala city, Haryana, Justice Bindal began his legal journey after obtaining his LLB from Kurukshetra University in 1985. He commenced practice at the High Court of Punjab and Haryana, where he went on to present key governmental bodies, including Income Tax Department and Employees Provident Fund Organization, before High Court and Central Administrative Tribunal. Justice Bindal has played a crucial role in interstate legal matters, notably representing the state of Haryana and in the Satluj-Yamuna water disputes before both Iradi Tribunal and Honorable Supreme Court of India. Elevated as a judge of the High Court of Punjab and Haryana in March 2006, his judicial and administrative contributions have been multifaceted. He has chaired multiple national level committees, including those on electronic evidence, international child abduction, and litigation management system. His visionary work in integrating technology into judicial process led to development and replication of key software systems, which is centralized medical, legal, and postmortem reporting platform, which is now used across several Indian states. During his tenure as a High Court judge in various states, including Punjab and Haryana, Jammu and Kashmir, and Calcutta, ultimately as the Chief Justice of Allahabad High Court, Mr. Bindal spearheaded significant advancement in judicial infrastructure and digital reforms. His leadership was also pivotal in driving the use of artificial intelligence and automation in legal services, especially to aid access to justice for weaker sections of the society. His judicial journey is marked not just as a legal acumen, but also deep commitment to systemic reforms, administrative efficiency, and technological innovation within the judiciary. Please join me in extending a warm welcome to Justice Bindal, an eminent luminary. May I also request Mr. Ratan Singh to hand over a bouquet of flowers on behalf of the SCL to Justice Bindal. We also have with us today Justice Advait Sethna, Judge of the Bombay High Court. It is with immense pleasure and deep respect that we extend warm welcome to Honorable Justice Advait Sethna, who was appointed as the Additional Judge of the Honorable Bombay High Court on October 25, 2024. Born on 11th October 1976 in Mumbai, Justice Sethna brings with him distinguished academic and professional pedigree, a graduate in commerce from Jain and first-class law graduate from Government Law College, where he stood second at the Mumbai University and first in his college. Justice Sethna pursued his legal education further with LLM degrees from both Mumbai University and Chicago Kent College of Law, USA, where he earned high honors international comparative laws. He is also Salzburg Global Seminar Fellow with advanced training in law teaching and legal research from Cardiff Law School, UK. Enrolled at the bar in 2000, Justice Sethna built an illustrious practice at the Bombay High Court, known for his work in constitutional law, IPR, arbitration, and commercial litigation. Beyond litigation, Justice Sethna has contributed richly to academic and public interest. He has served as a part-time professor at Government Law College, Mumbai, and a visiting faculty at NMIMS, while also acting as arbitrator, mediator, and an amicus in significant matters, including those affecting prisoners' rights during COVID pandemic. It is our privilege today to welcome Justice Sethna, whose profound knowledge, integrity, and commitment continues to enrich the judiciary and inspire the legal community. May I now request Mr. Ratan Singh to please give him a flower bouquet on behalf of SCL. We also have Justice Indu Malhotra, former judge of the Supreme Court of India. It is an honor and privilege to extend a heartfelt welcome to Justice Indu Malhotra, an eminent jurist and respected voice in the Indian legal and judicial fraternity. Born on March 14, 1956 in Bangalore, Justice Malhotra completed her schooling at Carmel Convent School, Delhi, and went on to earn bachelor's degree from Lady Shri Ram College and master's degree from Delhi University. She began her academic career as a lecturer in political science at Miranda House and Vivekananda College, Delhi University. Her transition to the legal field was marked by excellence from the outset. After completing her bachelor's of law from Delhi University in 1983, she enrolled as an advocate the same year. She topped the Advocate on Record exam in 1988 and was awarded the prestigious Mukesh Goswami Memorial Prize. A trailblazer woman for women in legal profession, Justice Indu Malhotra became only the second woman to be designated as a senior advocate by the Supreme Court of India in 2007, breaking barriers after 3 decades. With a specialization in arbitration law, she has represented clients in numerous domestic and international commercial arbitrations and has served as a sole arbitrator under several reputed institutions. She holds a diploma in international commercial arbitration from Chartered Institute of Arbitration, England, and was empaneled as arbitrator by SIAC. Justice Malhotra contribution extends well beyond the courtroom. She was a member of the high-level committee formed by Ministry of Law and Justice in 2017 to enhance institutional arbitration in India and recommended legislative reforms. An accomplished author, Justice Malhotra has written the 3rd edition of Commentary on the Law and Practice of Arbitration and Conciliation, a benchmark reference for arbitration practitioners across the world. And I'm sure all of you would have used her book at some point in time. Throughout her distinguished career, Justice Malhotra has exemplified intellectual rigor, integrity, and deep commitment to justice and public service. We are honored by her presence today and extend a warm welcome to her. May I now request Mr. Ratan Singh to give her a bouquet. We also have with us today Mr. Bhushan Gagrani, Municipal Commissioner of Mumbai Municipal Corporation. It is my privilege to introduce Mr. Shri Bhushan Gagrani, a distinguished officer of the Indian Administrative Service from 1990 Maharashtra cadre. Born in Kolhapur, Shri Gagrani has dedicated over 3 decades of public service, shaping policies and development across Maharashtra. Currently serving as the Municipal Commissioner of Mumbai Municipal Corporation, Shri Gagrani oversees the civic administration and infrastructure of Mumbai, playing pivotal role in the city's progress and governance. His illustrious career includes key leadership roles such as CEO of Maharashtra Industrial Development Corporation, Vice Chairman of SIDCO, and Secretary in several vital departments including tourism, medical, education, health, and family welfare. Shri Gagrani's academic credentials are equally impressive, holding a Master of Commerce from Shivaji University, a Bachelor of Law from Nagpur University, and an MBA from University of Birmingham, UK. Notably, he is the first IAS officer to clear the UPS exam in Marathi, reflecting his deep-rooted connections with Maharashtra culture and language. Throughout his career, Sri Gagrani has been recognized for his innovation, approach, and governance, particularly in industrial development and tourism, significant contribution to Maharashtra's economic growth. His commitment to public welfare, administration, excellence, and visionary leadership have earned him widespread respect and admiration. Please join me in welcoming Shri Gagrani. May I now request Mr. Ratan Singh to please give him a bouquet on behalf of SCL. We also have with us Mr. Alexander Fesses, Secretary General, ICC International Court of Arbitration, Director of ICC Dispute Resolution Service. Mr. Fesses read law at University of Athens in Greece and specializes in international commercial transaction and conflict of laws. Earlier in his career, he acted both as counsel and administrative secretary in international and domestic commercial arbitration cases in construction, energy, telecommunication disputes. He joined the ICC Court's Secretariat in 2011, and today, as a Secretary General, he oversees the operational management of the entire Secretariat and other dispute resolution services across the globe. Welcome, Mr. Fesses, and please, may I request Mr. Ratan Singh to please give him a bouquet. It is my distinct honor and privilege to now welcome our very own Mr. Ratan Singh. A senior advocate practicing in New Delhi, Mr. Singh needs no introduction to this audience. However, for those who may not know him, he is the founder and chairman of Indian branch of the Society of Construction Law, and because of whom this conference is happening today, and an international member of prestigious Keating Chambers, London. He also serves as honorary professor of law at Manipal Law School, where he continues to inspire the next generation of legal minds. Mr. Singh brings with him over 25 years of rich experience in high-stake litigation and arbitration, both in India and internationally. His legal journey began after earning an MSc in geology, followed by an LLB from Campus Law Center, University of Delhi. Since joining the bar in 1996, he has become a leading figure in construction, engineering and infrastructure and commercial arbitration, having represented clients and served as arbitrators in the numerous complex and multi-million-dollar disputes. Mr. Singh is also the director of the Indian branch of Chartered Institute of Arbitrators. Mr. Singh is empaneled as an arbitrator with prominent institutions including the Singapore International Arbitration Center, Delhi International Arbitration Center, Indian Council of Arbitration, and several international platforms. In recognition of his expertise, he has been conferred 5 prestigious international fellowships, and he is notably the only Indian fellow of the International Academy of Construction Law, a highly exclusive global body of top-tier construction lawyers. Please join me in extending a warm welcome to Mr. Ratan Singh. Last but not the least, our very own Mr. Vyapak Desai, who is the co-chair of the SCL Mumbai chapter and a partner with Nishit Desai, an associate. We all know his contribution to the field of arbitration, and he will join the panel. I now request Mr. Ratan Singh to continue the day's proceeding.
Thank you for the wonderful introduction, sir. To commence this auspicious occasion, I request our esteemed dignitaries to kindly come forward for lighting of the ceremonial lamp, a tradition that symbolizes the spreading of wisdom and knowledge. It is now my privilege to invite the chairman of SCL India, Mr. Ratan Singh, to deliver the welcome address and set the tone for today's proceedings.
My Lord Justice Bindal, my Lord Justice Sethna, my Lord Justice Indu Malhotra, Mr. Gagrani, Mr. Alexander Fash, my colleague, Vyapak Desai, esteemed colleagues from all across the globe, foreign dignitaries. I see so many faces, known faces for decades here sitting in this hall. We have somebody from ICC Paris sitting there, Alexander. His report, ICC report says that 40% ICC's workload and arbitrations are construction arbitrations. Construction, engineering, oil and gas. I had words with Ladyship Justice Indu Malhotra. She said, so many construction arbitrations. Yesterday, I had a pleasure of being on the next seat with Mr. Justice Bindal, and we had almost 2 hours of flight, and we were talking about it. And again, we were talking about what are we doing with construction disputes. Ladies and gentlemen, SCL, Society of Construction Law, is one global organization which promotes education, research in construction law and construction arbitration. In India, till decades ago, I would say, most of the people, even lawyers, even the people in industry, construction industry, were not aware that there is something called construction law. We all thought that contract law is all about what we do and apply in construction disputes. This is when I'm reminded of a very apt, I would say, speech of one federal court judge of USA, when he said that construction law and construction arbitrations are different breed of animals. We have our construction law has got its very developed jurisprudence. It's not only contract law or advanced version of contract law. And this is how, and this is why, SCL came in India. I remember I was for an arbitration, I was in London for an arbitration in 2012. And I happened to meet Mr. John Takaberry Casey, one of the oldest now in London, right? Mark will agree with me, it's one of the oldest. They had started, the group of people like them, and many like-minded people who are practicing construction law in UK, they put together all stakeholders, construction lawyers, construction arbitrators, construction barristers, solicitors practicing construction law and advising on this, architects, engineers, quantity surveyors, delay experts, quantum experts put together. And then they came out with Society of Construction Law. And one remarkable thing which they did was, they created a protocol. First edition came out in 2002, though SCL was established in 1984, if I'm not wrong. It took years of efforts to create this one document, which is like a Bible, or which is like a civil procedure code for construction lawyers, construction professionals, claim consultants, delay experts, quantum experts, all stakeholders. every single delay analysis or delay analysis report anywhere involved, every single such report will refer to one of the methods of SCL delay and disruption protocol. Various jurisdictions across the globe have had occasion to deal with this protocol of SCL. Now, I happened to meet John Takaberi. John said, hey, you practice construction law, construction arbitration. Why don't you start this SCL in India? I came back and I founded SCL in India for the first time in 2014. Then put together like-minded people who were practicing generally on construction side. And one of the things which were crossing our mind was that my generation of lawyers who were practicing construction arbitration and working on construction disputes were all self-taught. So one of the ideas was to do something for the people, the younger generation, the people who were pursuing this area of practice, to create a platform. And what was crossing my mind, so we put together like-minded people. Tejas was, I brought Tejas on the table. Vyapak is here, Raj is here, Ajit is here. Many of such people. LR sits here. He is one of the vice chairs, Mr. Lakshmanan. So this is how this journey started. Then I thought that unless we do, Society of Construction Law, SCL, organizes its international conference. We have branches of SCL all across the globe. So in different countries every year we do organize such events. But every country would like to have this SCL international conference in their jurisdiction. So I remember 2016 I was invited to speak in Sao Paulo in SCL International Conference, which is organized jointly by all SCLs from all across the globe. So in every SCL International Conference, countries which want to have that conference in their respective countries have to give their bid. Not by, like contractors think, you have to say that this many crores. No. So you have to say, I want this international conference to happen in my country. I gave my bid. An interesting thing was, North Americans said, we also want to have the next one in North America. They said, and North America means US and Canada. So they say, we are US and Canada, we are North America. I said, hey, I'm India, 1/6 of the population. Then we had 2.5 hours of marathon discussion as to why in India, not in North America. We succeeded. I was all alone. I succeeded in, and what happens is all chairs of all SCLs sit together and then decide. So after all these discussions, they said, your advocacy skills got you this. So first time in India, we had this conference in 2017. And after this conference, we do it in, it's 3 days event. So once we concluded that event, SCL chairs unanimously passed a resolution to say that it was best ever conference in India. That gave visibility, that gave platform to all construction professionals in India. That gave SCL this opportunity to bring together all stakeholders under one umbrella. This is how we started. Then what we decided was, now we will have our own flagship conference biennially, alternate years. This we have been doing since 2017. And this year we are doing it in New Delhi on 5th, 6th, and 7th of December. which happens to be biggest gathering of construction professionals, arbitrators, lawyers. And last time we had four foreign sitting judges from construction courts, 42 foreign top-level speakers. Thereafter, what we decided was, let us have one yearly event in Mumbai. We cannot think about India without Mumbai. So we last year decided to have one conference in Mumbai, and it was big success. Like Raj said, or Vyapak said, that house full. Last time, first edition, house full. Until 6:30, I remember, people were not ready to leave the hall. Because we have lots of conferences on arbitration. Top institutions like ICC, SEAC, I don't know, Shweta is there or not. They all do organize such events, but they are arbitrations generally. As I said, construction arbitration is a separate breed of animal. We must have one umbrella under which we talk about peculiarities of construction law, peculiarities of construction arbitration. And in fact, one good thing which has happened is we started teaching LLM in construction law in India. And we have the gentleman who is spearheading that course in Manipal Law College, Venkat, Professor Venkat. Let us give a clap to Mr. Venkat. Venkat said, you have to be the chair to design this course, and then you have to come and teach. I gladly accepted it, and then they say you are honorary professor of construction. It gives immense pleasure. When you pursue a particular subject with passion, put together all stakeholders under one umbrella and pursue it. It gives me immense pleasure in once again welcoming all of you, and more particularly the foreign delegates and speakers who have taken so much of time, so much of pain to attend this. Thank you very much.
Thank you, sir, for your inspiring words and for leading us into today's journey of learning and dialogue. We are truly privileged to have amongst us distinguished special guests who have kindly agreed to share their thoughts with us today. May I first invite Mr. Alexander Fassas, Secretary General, ICC International Court of Arbitration, to kindly address the gathering.
Honorable members of the dais this morning, distinguished members of the Society of Construction Law, dear participants, colleagues and friends, it's a great privilege and honor for me to be sharing these opening remarks with all of you here today out of Mumbai, a city that I have on many occasions had the opportunity to visit, not since the pandemic, and coming back, I was truly blown away by the amazing changes that are underway and have actually taken place in terms of its infrastructure. And perhaps what better way to segue into today's conference than to pay tribute to the resilience and dynamism of the city, and of course the commitment of its local authorities on the one hand, and the very strong presence and very strong willingness of the wider construction industry in making that transformation possible. You have heard already how oftentimes construction conferences seen from an arbitration angle speak more of arbitration than of construction-related matters, and that is true, and I will come back to that, of course, in a second, so please hold an asterisk there. But why are we interested in construction? Why are us disputes lawyers so infatuated with it? And why are we so interested in sharing and evangelizing the benefits of arbitration when it comes to construction matters and construction disputes? Well, the first one is that arbitration basically ensures the value of investment. It is a clause that is negotiated, a good clause if well negotiated, that can mitigate or at least manage contractual risk in a very safe and reliable manner. And so both parties or all parties within the construction chain stand to benefit from that. It is not just a factor that manages risk, but it also, if done correctly, maximizes the chances or the opportunities of enforceability, which of course means that you are in a position to collect, if ultimately that is what you need to do. If successfully negotiated and implemented, it also reduces the risk of dispute resolution needs, because you may actually settle the case. 1 out of 3 cases administered by the ICC arbitration at any given time, for instance, settle prior to the rendering of a final award. And we want the parties to do that. But more importantly, of course, and this is where construction gives us a very clear example, we want arbitration because it provides expert outcomes. And so it is for all of those reasons that we, the disputes lawyers, sing the praises of arbitration and other forms of ADR to the construction group. Now, why is it especially so important for the purposes of the ICC? First of all, because we are seen and we feel it, that we are the world's leaders in dispute resolution. This is not specific to France, which is a country where my home office is, but with the exception perhaps of this tie, there's nothing really French about me. I come from Cyprus, which is a very common law jurisdiction, very like India, a former colony, very much like India. And I would say that I have more parallels being here than when I do, on occasion, visit my office in Paris. And we can have a look at that by just looking at empirical data, not just the ICC caseload, but the Queen Mary, the forthcoming Warren Case Queen Mary survey on international arbitration, again, for the umpteenth time, identifies that for respondents from all around the world, and I should say that for this upcoming survey, about 50% of respondents came from Asia, and therefore it's particularly relevant for Asian parties, including Indian parties as well. ICC is the most preferred arbitral institution. We partnered just this year with Ernst & Young for an arbitration landscape study, and again, far and wide, for reasons that lie beyond the purposes of today's conference, we are identified as the world's leaders. And we take that very seriously, because ultimately the I in ICC really stands for the international character of our work. It doesn't really matter if the project has an Indian nexus, or a Singaporean nexus, or one in China, or the United States, or Latin America. The expertise that comes with the ICC brand is instilled in every single case through its secretariat and the court. And we can see that just by looking at very simple data, and I won't bother you a lot with it because brevity is also the soul of wit, as William Shakespeare used to say. So 841 new cases registered under the ICC rules last year, with a total amount in dispute, initial amount in dispute, of $102 billion. 1,800 pending cases at the very end of last year, with a global amount in dispute of $354 billion US dollars. Those are figures also, I think, indicative of complexity of matters that no other arbitral institution has or will administer if they really want to be in the business that we are. And amongst them, and I'm again grateful that the figures were already shared before I mention it, over 200 construction arbitrations registered just last year, and an additional 150 to 160 energy-related arbitrations, which may also have, as you very well know, they often have a construction nexus as well. And more importantly, and this is where again a huge differentiator comes on the quality of, or rather the typology of cases that we see, 1 out of 5 of those new cases involved a state or a state-owned entity, which is quite important given, of course, the role that SOEs play in infrastructure, especially public infrastructure. And lastly, and quite important also for the purposes of the Indian economy and projects here, 31% of our cases last year involved parties from the same region, which again I think is quite relevant when it comes to describing construction, the construction experience here. Now, in addition, because of this very clear link between arbitration, ICC arbitration, and construction matters, the ICC has had a very unique privilege in being the only one that had the opportunity to develop first and continue to do so very specific rules that address the construction phenomenon. To give you a very brief example, the main provisions on complex arbitration, Articles 6 through 10 of the ICC rules, are the product of practice. They are the product of practice that comes out of the administration of our services in construction-related arbitrations. Provisions that, with some relative success, have been echoed in other institutional settings as well. But you need to be able to have experienced the multi-party, multi-contract arbitrations, the existence of cross-claims, the multiple requests for consolidation, the difficult and sometimes extremely challenging task of having to constitute tribunals in cases involving multiple parties and multiple claims from around the globe, and ultimately in administering that arbitration, that you ultimately have that opportunity to develop those rules and practices. And the good thing about that is that ultimately there is acknowledgement from the construction community. And the very clear example of that is FIDIC, the International Federation of Construction Engineers, which has a long-standing collaboration with ICC, not only because ICC is the sole provider under the FIDIC contracts, model contracts, but also because we actually, very much like the society itself does, disseminate information on the way that construction arbitration works. We meet with FIDIC annually and we share our perspectives. We organize annually with FIDIC a joint conference, not just on arbitration matters, and here I would say that probably you're not holding a sole privilege, but we share that one with you, where we actually hear from the engineers and the application of the contractual provisions. And so there is this constant cross-fertilization that keeps the offering alive. There are, of course, because of that cross-fertilization, specific services that actually cater to the construction industry. Emergency arbitration, something that sometimes alleviates the heavy burden that the courts have when it comes to interim relief. Interim relief that can be provided ahead of an arbitration beginning that might be so urgent that it cannot await the constitution of an arbitral tribunal. We saw how often emergency arbitration has been used, especially in the construction industry and especially during the times of major disruption, such as COVID and also on other occasions. Obviously, the existence of other non-arbitration ADR services and the existence of escalation clauses work very well in an institutional setting like ours because we have dispute board rules, mediation rules, expert rules, and of course arbitration rules that can work either as steps, but can also work once one of those procedures has already been initiated, not as a condition thereof. And lastly, a point that I feel very strongly about, and a point which I feel that I must provide clarifications to avoid gross misunderstandings: the scrutiny of awards. I mentioned earlier that expert, valid, and enforceable outcomes are, of course, the reason why arbitration is being used. It's not because construction experts or arbitration experts love arbitration. I mean, lawyers definitely do, but that is not why we arbitrate. And therefore, you are agreeing to arbitrate because you want to be able to collect, and you want to be able to benefit from validity and enforcement, potentially global enforcement, if it's a foreign arbitral award. And of course, scrutiny is the advanced exercise of reviewing the draft award before it gets rendered with the sole purpose of enhancing its quality and also in ensuring valid and enforceable outcomes. It is a reliable solution. It is one that the ICC Court has been applying for decades now in its service, but it's not 100% fail-proof. There will be instances where scrutiny will not be able to pick up all the elements that could better the quality of the award or could avoid mistakes or errors that could prove fatal to the validity and enforceability of the award. Scrutiny is not there to second-guess the findings of the arbitrators or identify faults that lie outside the file that is before the ICC Court. And I mention this because there has been at least one recent example that has caused some attention, and there may be more reason for that same example to come back into life in the days to come. And so in thinking about this, please consider that no system, of course, is fail-proof. A reliable service provider learns from their experience and makes the process better. And of course, please also remember that arbitration, like any dispute resolution system, is quite complex, and it requires careful calibration of very different parameters, including, of course, the careful selection of the decision makers. And I would close perhaps by saying, and regrettably not to the external counsel, but to in-house counsel, the members of the judiciary who are here today, if you're interested in seeing how we apply all of this in practice, you're very welcome to observe an ICC court session and see exactly how the work is being done by the 190 ICC court members and the 170 strong staff of the ICC Secretariat. I'm again very, very pleased to be here with all of you today, and I hope that you will enjoy today's interactions, which will be fruitful. And again, I'm extremely pleased that this is happening this morning out of Mumbai. Thank you very much.
Thank you, Mr. Fasas, for your insightful address. Now, may I request Mr. Bhushan Gagrani, IAS, Commissioner, Brihan Mumbai Municipal Corporation, to kindly share his thoughts with us.
Namaste, good morning. Honorable Justice Bindal ji, Honorable Justice Sethna ji, Indu Malhotra ji, Mr. Ratan Singh, Mr. Alexander, Ronak Desai, all the members of SCL, friends and stakeholders of construction industry. First of all, I extend my best compliments to this second annual Conference of Construction and Arbitration. It could not have happened at more appropriate time, as the entire country, and particularly Mumbai, is witnessing unprecedented construction boom, whether it's in public sector or in private sector. To make this entire construction world more reliable, more responsible, more sustainable and more affordable, I think we need a very robust framework of construction laws and its implementation and its understanding as well. This will help in controlling the time delays for, unfortunately, we are known for, and the cost escalation as well. And for that, this initiative by SCL will help the entire community to deliver the best and timely completed construction projects. Right from the land laws to engineering laws to employment laws, environmental laws, the whole gambit of the construction laws under which it is being regulated I think it's a best forum for us to come together and deliver the best possible to the society. We have come a long way. I remember a few years back when our seniors used to define arbitration as a litigation between any two parties where government loses. And from there, the world of contracts and torts have been matured in a long way, and it's an entire education process for the public sector also, for the government people also. And I think with this initiative, we will go a step further to make entire framework of construction into a better society and better deliveries. So I wish all the best to this conference, and thank you very much for listening me. Thank you.
Thank you, sir. Thank you for your inspiring words. It is now my distinct honor to invite Honorable Ms. Justice Indu Malhotra, who has been a towering figure in the field of arbitration and whose contributions continues to inspire many of us. Ma'am, may I kindly request you to address the audience?
Honorable Justice Rajesh Bindal, Judge Supreme Court of India, Honorable Justice Advait Sethna, Judge Bombay High Court, Mr. Alexander Fisher, Secretary General, ICC International Court of Arbitration, Mr. Ratan Singh, Chairperson, Society of Construction Law, Mr. Vyapak Desai, Co-Chair, Mr. Raj Panchmatia, Secretary of the Bombay Chapter, Mr. Bhushan Gagrani, IAS Officer, who's a Municipal Commissioner of the BMC, eminent arbitration practitioners from India and overseas, my very warm greetings to each of you. It is my privilege to address you on the occasion of the second annual day of the International Conference on Construction Law and Arbitration, organized by the Society of Construction Law. Well, I think this conference is of prime importance, and frankly speaking, this is the reason why at the last minute, just 2 days ago, I decided to attend this conference, because today the bulk of arbitration pertains to the construction industry, with the growth of infrastructure in a big way in India. In fact, India is, I think, the third largest already in the world, where construction industry has gained great importance and has also been the largest recipient of the green projects from the World Bank. I am today going to just give some thoughts from my experience of being an arbitrator, both sole and as a member of a tribunal in domestic and international commercial arbitrations. And it's from that perspective which I wish to share some of my thoughts. One is that disputes arising out of construction contracts are very specialized and technical in nature and cannot be treated like any ordinary arbitration that we handle. They require technical knowledge and are complex. They involve a multitude of parties, employer, contractors, subcontractors, vendors, whose responsibilities and liabilities are fragmented. The use of project financing in international commercial transactions introduces another dimension of complexity, as the interest of lenders and other credit providers also plays an unseen role in some of these disputes. One aspect is, of course, with respect to the role of experts, and there are several cases in which we have appointed experts. There have been cases where parties normally engage their own experts. The problem which we face as arbitrators is that party-appointed arbitrators normally sing the tune of the party which has nominated them, and therefore the objectivity and independence, it undermines their credibility, and it poses a challenge for the tribunal in the decision-making process to reconcile divergent views of the experts appointed by each of the parties. What does the arbitral tribunal do? It often, of course, takes recourse to hot tubbing between experts, or we also appoint experts, independent experts ourselves, to reconcile the, if there's a huge divergence in the views taken by the experts. Second is the nature of disputes being very complex, and the sheer volume of documents is overwhelming in construction contracts. It runs into frequently 500 volumes, because the entire, construction documentation, etc., everything is, bombarded in the office of the arbitrators, and then to weed and turn that out, we take recourse to having convenience compilations filed by the parties, because otherwise it's impossible to traverse such huge volumes of paper. Some of the issues which arise are interpretation of key contractual provisions, and sometimes, and this is particularly, I want to give a message to the public sector undertakings, there are inconsistent provisions in the contracts, because these are standard form contracts, and the contractor really has no role to play in the negotiation of the contract. These are standard forms, and you have to sign on the dotted line. So I do believe that there has to be a periodic review of the construction contracts, keeping contemporary realities and ground realities in view. Of course, there are also issues of variation in the design and structure which take place while the construction is midway, which can result in added costs, expenses, losses, delays, and the requirement for extension of time. So if extension of time is to be granted on account of design changes, etc., and structural changes, then no LD should be imposed. These are, I think, issues which need to be ironed out in the contract itself. The disputes which pertain to breach of contract, wrongful termination, wrongful invocation of bank guarantees, withholding of retention amounts, security deposits, and by contractors, non-rectification of defects during the liability period. These are primarily a large number of issues which are raised in in the construction industry particularly. Considering the fact that these documents are very voluminous, which include the contemporaneous records such as the DPRs, that's the daily progress reports, the monthly progress reports, minutes of meetings, work programs, etc., I think it is essential to deploy effective case management techniques in the construction arbitration mode of dispute resolution, because we cannot go blindly by what the parties say. We determine on the basis of the contemporaneous recording of the events as they're happening at the ground level. In fact, I have seen it in every construction matter I have done, that the contractor always has, letters being reeled out every single day that this is a delay caused by the employer because they want to take advantage of it at the end of the day. There's nothing wrong with that, but the point is that you can't rely upon that as a basis to make your assessment determination. We go by minutes of meetings signed by both parties, etc., etc. So therefore, I think the process needs to be streamlined. Second is in international construction disputes which involve different jurisdictions, compliance with the governing law of the jurisdiction where the contract is being executed and the law of the seat where the arbitration is being conducted add to the complexity of disputes. From my practice as an arbitrator, I find that a major concern for developing countries in construction arbitration is the practice by multinational construction companies which invoke the arbitration clause several times in one commercial contract. They treat each key milestone as a cause of action, invoke one arbitration, and after the next it goes on, and there are overlapping claims made, there are different tribunals constituted, there are costs imposed, there is an element of interest, and the costs of financing this arbitration itself is very overwhelming, and a great depletion and diversion of resources from development to defending themselves in these disputes. This is actually a matter of serious concern in developing countries. And I do believe the practice of splitting the cause of action against is certainly contrary to the fundamental rules of res judicata and order to rule 2 of the CPC. The Delhi High Court in Gammon, India, and I want to quote two of the judgments. One is Gammon, India versus National Highways, where the Delhi High Court said multiple arbitrations before different tribunals in respect of the same contract is bound to lead to enormous confusion. The constitution of multiple tribunals in respect of the same contract would set the entire arbitration process at naught, as the purpose of arbitration being a speedy resolution of disputes, constitution of multiple tribunals is inherently counterproductive. Oftentimes, there are tribunals which may have given one ruling in Keystone 1, and in the next key milestone, another tribunal may give a completely contrary view on the basis of further evidence which has come on record. So it is a very problematic situation. And the Indian Supreme Court in Dolphin Drilling versus ONGC had also observed that the issue of financial burden caused by the arbitration proceedings is indeed a legitimate concern, but the problem can only be remedied by suitably amending the arbitration clause. One of my friends who's here, Mr. Shaurav Lahiri, an eminent construction lawyer, he mentioned to me an interesting example from the 1999 edition of the Hong Kong Government General Conditions of Contract, wherein clause 86 provided, and I would like to read it to you all. No steps shall be taken in the reference to the arbitration until after the completion or alleged completion of the works, unless with the written consent of the employer or contractor. So except with the written consent, it can take place only once, which is at the conclusion of the contract is either executed or terminated. You can't have multiple arbitrations because it's becoming very problematic. Multinational construction companies may have the funds to do it, but frankly speaking, it's counterproductive in the long run if you get divergent views by different tribunals. Another issue, and this is an issue which I do want to address to the public sector undertakings and their council, I find that the respondent state entities, this is only the respondents because they have a tendency to raise frivolous counterclaims which are more by way of a counterblast. Frivolous counterclaims lead to unnecessary expenditure of time, money and effort, and parties are compelled to defend claims which lack substance, and I find most of the time that there is no evidence to support it, so they get thrown out on that ground. But the more serious issue is, and that is what I want to bring to the attention of all PSUs and state entities, that the tribunals often impose costs on frivolous claims, counterclaims being made, and this is also provided in our Act. Probably it's mostly overlooked, but I will read it to you all. It's in section 31, capital A, section 3C of the Indian Arbitration Act, which says that the tribunal shall have regard to whether a party has made a frivolous counterclaim leading to delay in the disposal of arbitral proceedings. So this can be a ground for imposition of costs on the respondents. So please be fully deliberated before you make counterclaims. Don't do it just by way of it being a counterblast, because it can be counterproductive. You can be visited with costs. I also believe that some standard operating procedures ought to be framed containing best practices of contract management for PSUs to handle and manage these disputes. One of the most important issues I feel is in the selection of the arbitrators who are appointed to deal with construction disputes. It is a subject which certainly requires domain knowledge, and additionally, I feel what is of critical importance is also that there must be regional diversity in these panels, arbitration panels, because it's people from the region who understand the peculiarities of the problems which arise. And as everyone knows, that the constitution of the tribunal is key in determining the outcome of the dispute. I would like to flag certain issues before I conclude. One is drafting of arbitration clauses which bar successive arbitrations, I feel is of importance. framing of an SOP to be followed in construction disputes. Thirdly, this is again for the PSUs, land acquisition and statutory clearances should normally be obtained prior to issuance of letter of award, because a lot of time is taken frequently in the acquisition proceedings, so the contractor cannot be visited with penal consequences by imposition of liquidated damages for delay in execution of the project. So this should be kept in mind, because this is actually a major cause of concern. And these are broadly some of my thoughts. And I feel if we get down to adopting with, I think, the most eminent construction practitioners who are sitting here in the audience to help develop a good SOP in the construction industry, it will enable India in leading the narrative, in shaping arbitration practices in the global south, advocating frameworks which reflect regional priorities while maintaining global standards, and would significantly improve dispute resolution in complex infrastructure and construction disputes. Thank you for your attention.
Thank you, ma'am. Thank you for your profound and thought-provoking address. Moving forward, it is my immense pleasure to invite our guest of honor, His Lordship Honorable Mr. Justice Advait Sethna, to kindly address the gathering.
Honorable Justice Rajesh Bindal, Honorable Judge, Supreme Court of India, Honorable Justice Indu Malhotra ji, former Judge, Supreme Court of India, Mr. Ratan Singh, Chairman, SCL India Chapter, Mr. Alexander Fishes, Secretary General ICC, Mr. Bhushan Gagrani, Municipal Commissioner BMC, Mr. Vyapak Desai, Co-Chair SLC Mumbai Chapter, along with his colleague Mr. Raj, dignitaries on the dais, off the dais, foreign delegates from various countries, ladies and gentlemen. Good morning, warm greetings and namaskar. I am honored and delighted to be a part of this prestigious event taking place here today. At the very outset, I must compliment the organizers of the SCL Mumbai chapter for aptly selecting the theme of setting the tone for building a better tomorrow. The expression building would connote creation, and in the context of nation building assumes special significance. Construction, which was earlier associated and restricted to building houses or homes, has undergone a paradigm shift in the modern contemporary times of today. The context of buildings has transformed to encompass public-private partnership projects, including building of roads, highways, metro rails, power projects, refineries, and several others, which would today constitute the backbone of economic progress and development of a nation, particularly such as ours. When we speak of the world as one family, the concept of Vasudhaiva Kutumbakam, which often all of us hear, what unites us with the larger family at the macro level is infrastructure, where construction law has definitely a pivotal role to play. At this juncture, I am reminded of the words of Margaret Thatcher, who said, and I quote, "You and I come by road or rail, but economists travel by infrastructure." The laws are dynamic and changing. I came across this inspiring quote of Justice Bindal, who once said, "Law is not static, it goes with the society. You should keep your eyes and ears wide open to see what is happening in the society." I am sure this would resonate with all of us today in the context of the evolving stream of construction law, a niche and specialized area, as my co-speakers echoed, which is growing at a rapid pace with the changing demands of the Indian diaspora as across the globe. When the law grows, the issues, challenges arise, mandate the need of a robust dispute resolution mechanism, which would include arbitration, particularly in construction disputes. Being one of the most effective dispute resolution mechanisms for redressing the complex disputes that arise when one refers to the area of construction law, which would range from EPC, which you all know, engineering and procurement contracts, build, operate, transfer contracts, design, build and operate contracts, amongst others, where public-private partnership plays a crucial role. Construction law, in my humble view, is impacted and influenced by a confluence of various legislations, as Justice Malhotra also referred to, including the Indian Contract Act, the Specific Relief Act, the Arbitration and Conciliation Act, which would come into play when arbitration is chosen as a dispute resolution mechanism in such contracts, often the practice followed in India as well as across the globe. In this context, when one deals with construction contracts under the canopy of construction laws, practically one would encounter issues relating to interpretation of clauses of such contracts at different stages to encompass issues of delay, breach of contract, and resultant damages, which, if I may have the liberty to address this as the trifecta or the DBD trinity, that is delay, breach, and damages, which law practitioners, adjudicators, judges often come across. Pardon me, due to paucity of time, I may not be able to cover all of these, which I'm sure will be a part of the intriguing sessions to follow. However, when one refers to damages, as Justice Malhotra spoke about, the celebrated decision in the case of Hedry versus Baxendale comes to mind. Section 73 of the Contract Act embraces the principles of unspecified or unliquidated damages, and Section 74 refers to liquidated damages to include predetermined sum of damages. This many a times becomes a vexed issue in construction disputes, particularly in cases of anticipatory breach of contract, when a party declares their unwillingness to fulfill their contractual obligations. At this juncture, I would also refer to a celebrated decision of our Supreme Court in Kailashnath Associates versus Delhi Development Authority, where the Supreme Court emphasized that if a contract designates a specific sum as liquidated damages, the party alleging breach can receive the predetermined amount only if it represents the genuine pre-estimated damages mutually agreed between the parties. Similarly, where a fixed amount serves as a penalty, the court can award only reasonable compensation, which ought to encompass the stated penalty amount. These are fundamental to the disputes that arise under the realm of construction law, more particularly construction contracts. Another decision which comes to mind and which needs to be gainfully referred to is the case of CC Constructions versus Akon International, recently decided in January 2025, where our Supreme Court observed that even contractors ought to reserve their rights while seeking extension of time to complete a project, as not doing so might bar them from making any claim in the future, as was held in the decision, which would have far-reaching ramifications in the field of construction law. Another significant decision, which I may quickly refer to, would be that of the Delhi High Court in the case of Union of India versus ANS Constructions, where the Delhi High Court rejected the employer's imposition of 17 lakhs in liquidated damages on the premise that actual loss was not proven. It reaffirmed that employers cannot impose liquidated damages unless genuine loss is shown and when the employer is responsible for delay. In this context, I must also mention the celebrated decision of ONGC versus saw pipes, which has left a mark as far as arbitrations in the country are concerned. Pondering over the pragmatic aspects of the practice of construction law, I would share some insights. One of them would be adopting to technology, which is in the practice of construction law can play a vital role, particularly in handling complex engineering design drawings, which are often used in large-scale projects. Today's buzzword, AI or artificial intelligence, would have its own bearing and impact and may yield positive results if used in a controlled manner and not as an unruly horse. Another area would be that of drafting contracts, evidence collection and presentation, use of digital tools which one cannot lose sight of to improve efficiency and accuracy, which one needs to be aware and abreast of. As I referred to earlier, the starting point as also in construction disputes would, as Justice Malhotra spoke about, would be delay, and hence the importance of delay disruption analysis, which would form an integral part of the discussions today. Here, practitioners and dispute resolution professionals like arbitrators who handle such specialized disputes ought to have a robust technical understanding coupled with a pragmatic, business-oriented commercial approach, which, when dovetailed with the applicable legal provisions, would ensure not just speedy but effective resolution of construction disputes. An illustration that comes to my mind from my practice days, which is not very long ago, is in the case of EPC contracts and the distinction between EPC contracts and item-based contracts, where a clarity is required to determine positive and productive outcomes. In international jurisdictions, referring to Singapore, UK, USA, Malaysia, Australia, among others, one would be familiar with DABs or dispute adjudication boards in such disputes before invoking the arbitration clause. By doing this, it is intended to keep a long-term project on track by providing a quicker resolution to disputes and avoiding cash flow disruptions. This was suggested by the International Federation of Consulting Engineers, an organization for construction technology and consulting engineering. Interestingly, the Swiss Supreme Court has opined that if the parties have skipped such pre-arbitral steps, a stay in arbitration proceedings can be granted. However, referring from annulling the award in those facts and circumstances. We are not far behind. The Indian equivalent to this would be a clause in the EPC contracts where it is often mandated that parties to settle disputes amicably as a precondition to invocation of arbitration. Here, an important decision of our Supreme Court in NHAI versus Transstory India Limited comes to mind, where the disputes in an EPC contract was held to cover the termination as primary dispute and not just merely claims or counterclaims in the context of resorting to conciliation before invoking the mechanism of arbitration. In my concluding remarks, as I wish the very best, and again heartily congratulate the organizers of this conference for bringing together stakeholders from the construction industry, experts in the field, whose assimilation today with seamless sharing of their innovative thoughts, ideas would go a long way in shaping the relatively nascent but fast developing field of construction law and disputes resolution through arbitration, which are closely intertwined by a common thread as encapsulated by the Latin maxim, which all of us are familiar with. It is ubi jus, ibi remedium, where there is a right, there is always a remedy. Thank you very much. Thank you, sir.
Thank you, sir. Thank you for your very inspiring and motivating words. We are truly honored by your presence today. Finally, the moment we have all been looking forward to. May I now invite our chief guest, His Lordship Honorable Mr. Justice Rajesh Bindal, to kindly deliver the keynote address.
A very good morning, dignitaries, honored of the dais. I'm not taking names because we are already running late, I think. And a lot has been said about technology. So in technology, there are two terms used, copy-paste also. So I can always copy-paste whatever is said earlier. And second thing is, this is a subject which is very important and is being dealt, it's required to be dealt by the experts. On the dais, you have already heard the expert speakers. And I am a layman, basically. And I think from whatever has been said, I have also learned a lot of things. Had it been in court, where we have multi-member bench, and one of the sister or brother has written a judgment, in the end, you can always say, I agree. But here, that option is not available because I have to justify my being here. And a lot has already been said, but still little bit thought which I have, I think I'll share with you. Construction, yes, we all know, and outside the hall also, the people who are not involved in anything, in law or anything, they also feel the effect of construction. You are going on a road, you will say some blockade is there. Some dust is there. In Delhi, they stop the construction activity during November, December because of the pollution level. So everybody has a feel of that. And especially if you see, sister had shared about Global South and all that. A lot of development activities and creation of infrastructure is going on in this part of the world. Because developed countries, they have a lot of infrastructure already, so little bit is being backed up, maybe some improvement is there. But in this area, there is a lot of new construction being raised, and especially of infrastructure, which we are seeing, we are feeling daily on a regular basis. Now, if you see a little bit, I'll share volume, because we are dealing with the construction industry and the disputes, law or the arbitration for that. You have building construction, maybe residential also, maybe commercial types also. Some infrastructure, we all know what kind of infrastructure is being created. Industrial also is there, and a lot of issues. In fact, it's a growth-driven area, because a lot of spending in this area is by the government only. And government support once comes, it has large circulation of money then. It percolates up to very lower level in this. India is presently the 5th largest economy, we know, and gradually going to be, I think, 4th, maybe next year. Whatever I have read in the construction market, if we see, in 23 it was 76 lakh crore rupees. It's not a small amount. If the volume is so much, so naturally some dispute, something will be there. You can't avoid that. And it is stated to be about 182 lakh crore by 2030. So a lot of future is there in that. And future and the progress, you see, is about 10.4% per annum. This is the growth rate. Investment also, I see, in 2019-23, the investment in this area was about 4.25 lakh crore, which is stated to be in 24-28 is about 6.78 lakh crores. It's a huge investment coming in. Government of India also launched, there is a term used, National Infrastructure Projects. 2025, their projects estimated were about 6,000. But in fact, presently, ongoing projects are more than 9,000. So they are regularly adding, and the amount of investment has been revised from 111 lakh crore to 147 lakh crore. This is the government of India doing. And FDI in construction is also huge. It's about, I think, 37,000 crores. If you see the major areas in construction, because we are dealing with that, in railways, average construction of railway track per day is about 14.5 kilometer. So that shows some investment, some work has to be done. A lot of new things coming in the 20, and the projects, important projects, you see the undersea tunnel. In Mumbai only we are having all this underground metro also. Then we have the world's highest river bridge. Many of you must have heard about it. It's in Jammu Kashmir. I think worth seeing. I had the opportunity to see that when it was being constructed. It's a state-of-the-art, I think, technology used. Not only the technology, even the safety also of that. Because say wind tunnel there, a lot of air pressure remains, so they have to make it safe. Earthquake, I think 7.5 or something. It's earthquake safe also. Then we have the highest statue in our country. We have the largest stadium also in our country. So a lot of things are coming in, and I think many first will be there in our country also. If you see the metro is another area where a lot of growth is there. India is at number 3 if you see the metro network. We have surpassed Japan. Japan had about 900 kilometers, we have 1,000 kilometers now. And I think very soon, maybe 3, 4, 5 years, we'll surpass USA also. USA is about 1,400 kilometers only. China is far ahead, may be difficult, it's more than 10,000. And regularly, lot of kilometers in metro also are being added, lot of projects in pipeline. Highways also, daily construction of highways is about 34 kilometers. It's not a small thing. That shows the huge investment. In 24 only we constructed about 12,000 kilometers of highways. This is the kind of work being done. And a few days back only, a project of about 166 kilometer long highway in Northeast, more than 20,000 crore rupees has been sanctioned. So all this construction activity will once goes. And similarly, housing also you have, housing delay is very important because of RERA. Because if the project is delayed, the date of possession is naturally promised to the subsequent buyer of a flat or a property is delayed, so a lot of litigation comes in. So that's very important in that also. Now you are seeing a lot of ports being constructed. Recently one has been inaugurated by our Prime Minister. This is one part of how much investment is going on. Second is very important part in this, the labor being employed, the generation of, and especially you have unskilled labor in this, most part of it. The labor force, workforce employed in these construction activities is more than 7 crore, not a small amount. And 81% of that is said to be unskilled, only 19% skilled. So that is a major employment generator industry. So any dispute, any delay, any kind of a problem in this area has a large ramification down the line, because if the dispute is there, maybe the labor will also suffer in that. So that's very important that this is resolved at an early stage also and with a fast pace. Post-COVID also we have seen the kind of development our country, the kind of shift of manufacturing activities from world over because of different reasons, we all know it. So that also is an area because of which a lot of infrastructure had to be created in our country. So this was the part where we have a lot of investment going on, lot of infrastructure projects going on. Now if we go to law, we have Contract Act, yes, Specific Relief Act is also there. Then thereafter, if we go for arbitration, then naturally Arbitration Act is there. But one part is there that for commercial contracts, we have the Commercial Court Act also. We have specialized commercial courts in our country to take care of all these issues. But one thing which has been done by the Parliament in Specific Relief Act, They added a specific section saying that no stay by the court for any infrastructure project, so that the delay is not there. Sometimes we know because of stays also, there are delays. Ease of doing business is one part that shows the growth and the confidence of the people in our country. In 2014, our rank was 142, which is now 63. In 23 or 24, it was 63. So that's the kind of improvement we have made in this. And for that, I can share that even our e-court project was also part of that only. Not part of that, but this was one of the factors they were considering. So a lot of computerization in court was also a reason for improvement of that scale or maybe the rank. One law is there in Singapore. This is regarding payments only in contractor industry. May not be that relevant because that's not resolution of dispute. Commercial Court Act is there, but one part is there, though there is a timeline for disposal of the cases in commercial courts. It's about 1.5 years, I think, the maximum. But still, there are some issues in that if we talk about practical part of it, because you need a lot of training for dealing with all these experts issues. Construction is one part. And arbitration, there are a lot of other issues also. Maybe all the judicial officers may not be equipped to deal with all these issues. So their training is, I think, most important part which is required and should be done. It's being done, but more emphasis should be on the expert part only, not the legal part, the domain part also. But one fact is there, many people talk about the delays in court. I just want to add one thing about it. It's not that work is not being done in our country in courts. You may be a little surprised to know the figures. There is about 2.35 or 40 crore cases filed in our country every year. For last 2 years, I can share with you. And except about 10 lakhs, means minus 10 lakh, the cases are being disposed of by only 20,000 judicial officers at what level. It's not that work is not being done. Huge work, 2.25 crore cases decision every year is not a small thing. But still, there are some delays, some cases are delayed, some are disposed of, but there is a normal life also of any case. What I learned, there are some specialized construction courts in some country. UK is there, Dubai, Malaysia, it is there, and somewhere maybe the list is there. But this is one part. Arbitration is a kind of private dispute resolution which is selected by the parties. Now I just saw the data about that also. Much has been shared by my earlier speakers. What is said in 2024, the dispute of this industry was about $16.5 billion, which is set to increase maybe $30 billion by 2032. But the problem area is more ad hoc than institutional. And especially in this kind of litigation, this kind of dispute resolution, more expertise is required, and we should move toward more institutional arbitration and not the ad hoc arbitration, because in ad hoc arbitration you will not find the experts. This being the highly specialized area, one thing which I would suggest is, why not have specialized institution also for this? We have a lot of arbitration centers throughout the country. They are dealing with all general arbitration matters. Why not have a specialized arbitration center for construction industry once we say about 50-60%, because we don't have authentic data about it, because there is no place this data is being collected of for the arbitration, not about the construction only. A specialized arbitration institute or society for this resolution of construction disputes. And for that, I think SCL can be of great help because they have the expertise, domain expert. You can have the legal experts also in that. Have good panel. See the kind of and quality of resolution being made, and maybe fast also. And you have seen the specialization in other areas also. If you see the medical side, we all know normally pathology is one of the subject. If you go deep into it, it's not simple pathology, there's one generic word. There are 3 major head and 14 subhead in that, all super specializations. So why not have that? This is one thing which in my opinion, should be done And maybe Mumbai being the financial capital of our country, a lot of infrastructure being created, should be the place where it should start. And we have the commissioner sitting here, he can also support. Maybe you need some infrastructure for that. And let us give a beginning to the word, I think, for that. Now another area. Yes, the effect of that will be the quality of award, where maybe the interference by the court will be minimal, which is required, I think, in private dispute resolution. Another area which has been touched by my elder sister Indu Malhotra ji is the drafting. A lot of litigation start with drafting also. We normally say that the statutes, especially the tax statutes, are very badly drafted, very complicated, should be simplified so that people understand all these. But the problem in the contract drafting is equally good. There is no dispute about it. There is no timely review of the contracts, the clauses, and in one of the cases, I will share what the Supreme Court said in 2009 about it. Just read 2 paragraphs from the judgment. The use of multi-layered agreements with several printed annexures, each one cyclostyled amendments, typed and handwritten additions and deletions lead to confusion, uncertainty, delays in execution, apart from giving rise to avoidable disputes. Having a contract with different annexures dealing with the same issues with various amendments in construction contracts and sometimes insurance contracts is a nightmare to anyone wanting to understand, implement, or enforce them. Complicating contracts with several annexures and attachments with inconsistent, irrelevant, superseded and redundant provisions resulting in creating a lush dispute-generating field. The best form of agreement is where all the relevant clauses, terms are incorporated in a single document with several sections dealing with each aspect subject, avoiding any overlapping. Clear, simple, and straightforward agreement is the need of hour. Tens of thousands of engineering contracts are being entered all over the country every day in regard to infrastructure work, without the necessary clarity leading to avoidable disputes and considerable strain on the exchequer. With the use of computers, with user-friendly editing procedure, with cut and paste facility, it is hoped that contract form appropriate to the work would be prepared to avoid redundancy, confusion, vagueness, and inconsistency, to increase efficiency, expedition, reduction of disputes, and saving of the funds. This is what the Supreme Court said in 2009. Because there is a lot of problem, and I attended one of the conference in arbitration recently, and one of the panel speaker in that shared a strange fact, I would say, that he said some of the clauses are left vague only so that they can decide which way the matter has to be taken in litigation. So mindset from the very beginning is a different thing. Sometimes where the arbitration has to take place or these kind of clauses. And another important area, as I shared initially, was that all arbitration should be institutional only. And if you take or give the work of drafting of agreements also to an institution which is an expert, like this is an expert body, maybe all these problems of drafting will go. And we have the clear clauses, defined everything, everybody knows the positive and negative points. And plus, the maintenance of record is a major area, for there is vacuum in the law, that who will maintain the record after the arbitration is over. Private arbitrator may or may not retain the record. Tomorrow, we have faced a lot of difficulty in court. After issuing the notice to arbitrator, the record was not produced in court. Sometimes, unfortunately, he may have died. And in all these construction contracts, the record is voluminous, if you see the hard copies. If the soft copy is there, that also is a big problem. Maybe if it is all institutional, then some responsibility of that institution only to maintain the record also, because maybe it is required at the stage of objections or appeal, or maybe sometimes in court also it takes time, maybe 1 year, 2 years, 3 years. Government attitude, I think, was evident from a scheme which was floated, Vivad Se Vishwas scheme. In 23 only, what I learned was that about more than 2,000 crore rupees were given settling a lot of disputes. That's the positive sign, I think, by the government. But the negative part for this is that in June 24, a letter was issued by the Ministry of Finance. They say in all contracts above 10 crore, the arbitration clause should be deleted. That shows now the government doesn't have the confidence in all this. This is the confidence which we all need to imbibe in this system. Otherwise, government being one of the major litigant in all areas and especially on these construction infrastructure projects, this confidence has to be rebuilt. And this can be only if the expert bodies are there and we all have the responsibility to do that. Recently, a judgment of the Supreme Court, you all must be knowing about the Constitution bench, that 142, Article 142 power can be exercised to be limited extent to modify an award. Very limited extent, they have defined it. Maybe it is for good. The time only will tell everything because certain views are expressed by the eminent lawyers and then the judgments are delivered. And another thing which I would say to conclude is that sessions, I think, are excellent on the subject. Every one of you, including me, will go enriched on this specialized subject. And the motto also is given, building a better tomorrow. I think for that we all need to join and then see that clause which has been deleted by the Government of India is again revived. With these few words, I'm thankful to the organizers for giving me an opportunity to learn, come and learn here something. Thank you. Jai Hind.
Thank you, Lordships, for gracing us with your presence and for setting a profound context for our discussions ahead. To formally conclude this inaugural ceremony, I now invite Mr. Vyapak Desai, partner Nishat Desai Associates and co-chair SCL Mumbai to deliver the vote of thanks.
Good morning and very close to good afternoon. The good news is the plenary session is over and I'm not here for any speech, only for delivering vote of thanks, which is possibly the most important part here considering the effort everyone has taken to be here today on Saturday. So on behalf of Ronak, who is the co-chair with me for SCL Mumbai chapter, thank you everyone, first of all, to be here. Can we have a round of applause for all the participants? I think apart from the people on the dais and the dignitaries, I think conferences don't happen without the participation. So I think we are very, very grateful for the support Mumbai is having for this kind of conference, and we promise we'll do this conference every year on the first Saturday of May. So next is first Saturday of May 2026. With that, let me thank you, give my grateful address to Justice Bindal for providing insight on the extent of construction and infrastructure projects and the requirement of the robust law and the procedures. I think that's where we all gather here, and he hit the nail on the head on those aspects. Justice Sethna, it's very difficult to tell or get him on the dais. I think we have worked together at NDA, so it's a very different feeling to have him on the dais. And he's the youngest judge today in the Bombay High Court. So a big round of applause for Justice Sethna and providing understanding on legal jurisprudence and requirement on development of law. Justice Indu Malhotra, always an inspiration. She brought amazing practical insights with her experience both at the bench and now as an arbitrator and doing a lot of policy matters. Mr. Gagrani, to thank you for participating and representing BMC and Mumbai today. It could not have been a better place but have you here and also provide such a great infrastructure and ecosystem in Mumbai. Though when it comes to construction and Mumbai, we get very, very disturbed, or sometimes, it's all about construction of roads. That's the only thing Mumbai talks about, but there is much more than that. when it comes to Mumbai infrastructure, and look at the coastal road, look at the metro projects, look at the other infrastructure, building, and so on and so forth. So thank you for taking the initiative and being part of this. And of course, Alex, thanks for giving the ICC perspective and taking the initiatives and providing the guiding light on how the construction disputes run across the world, which will help possibly India also to learn from the overall experience. And the last and the most important, Mr. Ratan Singh, for giving the vision to SCL in India, and also supporting without even questioning how Mumbai or Delhi or wherever it is. I think big round of applause for Mr. Ratan Singh to get here. Thank you, Akshay. Thank you, Mohana. Thank you, all the supporting organizations to get this conference running. So without taking any further time, we will go into the session straight away after this. Thank you, everyone, again.
Thank you, sir, for the heartfelt words of gratitude. May I now request Mr. Singh to felicitate the distinguished dignitaries on the dais. One group photo.